It's the 12th of August, 2024. Denise, take the roll, please.
You have to just unmute me.
I'll unmute you.
Patrick Halpin,
Present.
Frank Santos, Julianne Nolan, Jerry O'Neill,
Present.
Ed Wynn,
Present.
Juan Leon,
Present.
James Vaccaro, Greg Gaxiola, Nunzio Russo, Rich Casey. That's it. We have a quorum.
We have a quorum. Okay, we do have one public hearing today. Could we all stand for the pledge? Julianne, could you lead us in the pledge, please? Before we begin the public hearing, I'm reading this statement into the record. The planning board shall have the right to rely on any information that is presented by the applicant. If any such information is later found to be inaccurate or incorrect, the planning board may determine that any approvals, building permits, or other actions previously granted in connection with the application are null and void.
Item A on the agenda, public hearing, lifting of planning board covenants and restrictions. Job number 22-43D, Marcus Tepper, proposes the applicant is requesting permission to lift previously imposed planning board covenants and restrictions in order to legally maintain an existing outside cellar entrance and finished basement.
Okay, who's here on behalf of the applicant?
Hi, good evening. Christina Bravin, Morano Expediting. I'm the agent for the applicant.
Okay, do you swear to tell the truth, the whole truth, nothing but the truth?
Yes, I do.
Please proceed.
Okay, good evening.
Okay, but hold on, before you begin, the planning commissioner did issue a memorandum regarding this application dated the 31st of July, 2024. Have you had the opportunity to review this with your client? And
Yes.
And does your client or you have any concerns, any objections, or anything that you'd like to bring to the attention of the board regarding the items outlined in this memo?
No, we don't have any comments regarding the planning board.
Okay, and your client has no problems with any of the conditions, covenants, and restrictions?
Relating to the removal of the partitions in the basement, no objections.
Okay, it has to say, of course, the basement is open to be undivided, no plumbing fixtures, basement is for storage only.
Correct, and we have mentioned that on the plans that were just submitted. Those are small plans. We do have the large plans coming in, but they're just taking a little bit of time to print. So we'll bring that to the board as soon as they're available.
That's fine, please proceed.
Okay, thank you. So Mr. Tepper purchased this home in November of 2020, at which point this cellar entrance and finished basement was already constructed. There was no mention at the time of the sale that any of this was illegal, much less prohibited. Normally what happens, I'm sure you've heard this many times, they put money in escrow until things like this are resolved. So this was completely unbeknownst to him, unfortunately. So now he has the burden of remedying this situation. He was not made aware of this until we filed a pool application for him in May of 2022. So about 16 months after he took residence. We appeared before the Board of Zoning Appeals May 19th for relaxation of lot coverage, and were told about the covenant and restrictions. The building department was very kind enough to allow him to install the pool and move ahead with it, except it means he cannot have a C of O until we take care of this before you this evening. We did receive the planning department memo. He has agreed to all the recommendations. The board will look favorably on the application. Again, the plans you have before you are revised. One room has been created, with the exception of the unfinished utility room. Plumbing fixtures will be removed. The basement will be strictly used for storage moving forward. The modifications, once completed, will be inspected by the building department to assure compliance and issuance of a CO. Cellar entrances and finished basements are not uncommon in this area, and we ask that this portion of the application will be approved by the board to maintain that cellar entrance. It would be a huge financial burden for him to remove that, upwards of $10,000 at this point, some of the estimates that were received.
Okay, is that it for your presentation?
That's the end.
Do any of the board members have any questions? Jerry?
Yes, good evening.
Good evening.
The concern I have is that recently, in the recent years, the board has taken a position where the type of cellar entrance that is there now are prohibited. There's good reasons for it. People finish basements, they turn them into apartments with bathrooms, so that's something the board and the town does not want to have continue. Appreciate that he'll take the bathroom out, appreciate that he'll open the walls. I don't think leaving the cellar entrance that's there is something that we should lift when it's something that we've been imposing on all the other applicants who have come before us. What's happened recently is the egress windows are more common. People are obviously going to be in that basement for safety. They need to get out if they have to. So do you know what his position would be regarding that cellar entrance?
For the sole factor of the financial burden of trying to remedying that, he did, again, purchase the home this way, so now he has the burden of this. And he has zero intention of ever creating an apartment. He would comply to inspections periodically. I mean, the building department would certainly carry that out, especially if a neighbor was to say, I think there's something going on there, and he's been made aware of that as well, that if he was to go against the use of the basement as strictly storage, that he would most likely suffer the consequences of violation, and again, the covenant restriction would have to be kept in place, and he'd have to take care of that moving forward.
As I understand it, that addition and the roof over the entrance violates a rear yard setback as well.
I am not aware of that piece of the application. Oh, correct, yes, it is a diminished rear yard setback. I apologize, yes. But again, he did not create that, that was there. And we don't know how many years it was in existence prior to that, at least from 15 years prior to him purchasing the home.
Any other questions? No? Okay.
I have a comment, Mr. Chairman.
Yes, counsel?
You indicated your client wasn't aware of the restriction, correct?
Correct, when he purchased the home, it was not brought to his attention, or he would have done what typically homeowners do, is they put money in escrow until it's legalized.
So a covenant and restriction is like a deed.
Mhm.
It's recorded, and it's public record, and it's discoverable when you purchase a property,
Mhm.
and should be discovered. So, the fact that he didn't know about it doesn't mean that it's not self-created in a way, even though he didn't build it. He should have discovered it at the time of the purchase. So we're aware of the hardship, but we see this all the time. When this property was divided, in 2005, that was a restriction that was put on the development, and also there was some feedback from a fire marshal in the town that didn't want any habitable space in the basement. So it's normally a high hurdle to have that change, and this board doesn't take it lightly, the request to make that change. So anything else you can add that would be compelling to give the board evidence might be helpful to your client.
Outside of the fact that there are cellar entrances and, oh, I'm so sorry. Outside of the fact that cellar entrances and finished basements are not uncommon in residential areas, we don't personally have any cases that have been approved by the board. But again, his lawyer, his real estate agent, the owner of the property that sold it to him did not reveal this information to him. So it's not something that he would have probably taken upon himself to go to the town to find out. Most homeowners don't do that, or purchasers don't do that. They just presume that everything that's there, when the mortgage runs the title, it's legal. So unfortunately, the burden to remove the cellar entrance is upwards of $10,000 that he just cannot afford right now.
Are there any other questions? Thank you very much. Is there anyone from the public that would like to address this board? Seeing no one? Denise? Okay, so I need a motion to close this hearing, and we will reserve decision. Motion by Frank, second by Juan.
Second.
All in favor? This hearing is open.
Thank you very much.
Thank you very much. Okay, now that the hearing has been closed, the decision has been reserved in order for us to review the feedback we've received this evening and any open site plan issues. The record will remain open for written comments. To follow up on the status of the application or to submit additional written comments, you can contact the planning department in either of the following methods. One is in person. The planning department is located on the west wing of the town hall. Applications, documents, plans are available for inspections between the hours of 9 a.m. and 4 p.m. You can do it by phone, 631-957-3103, or by email, planning comments, that's one word, planning comments @townofbabylon.com. Thank you. Okay, that is the end of our only